Ms. Russo, ma'am, in sentencing you, it is my duty under the law to look at the seriousness of the crime, the effect that the crime has upon members of the community, your willingness to accept change in treatment, and what's available to me in the community to assist you in that process. The law directs that I do look at the least restrictive alternatives first and then proceed to the more restrictive alternatives. I consider what an appropriate rehabilitative plan for you would be, but I also must protect the interest of the public. In this case, the interest of the public is in having people with the idea that they can donate to charities without the fear of it being a scam. I have reviewed the pre-sentence report and have, of course, considered all of the information in that report. That report indicates that there are a number of good things about you. You have no prior criminal history. You came from a home while your parents were divorced, but you did apparently come from a loving home. You are not subject to any abuse. You were involved in activities and had many friends. You graduated from high school with a GPA of 3.7. You enrolled in St. Ambrose and graduated, or not graduated, but you were on the dean's list each semester with a GPA of no less than 3.66. At the time of your arrest, you were employed by Deere & Company, I believe in product marketing, as an intern. In short, I see little about your background that would indicate that you had not learned any better growing up, nor did I see any dire need for money. There was no substance abuse, no drug addiction. I think it is appropriate to briefly summarize the facts. On February 10, 2022, you began an elaborate scheme which involved you supposedly having pancreatic cancer and acute lymphoblastic leukemia. Through this scheme, you deceived your friends, your family, your community, other cancer victims, charities, and strangers who were motivated by your supposedly tragic story to donate to you to help support you through your disease. Most of these donations went into a GoFundMe account. Your scheme continued for a very lengthy period of time. You raised in excess of $39,000 from over 400 donors. I learned today that with Ms. Oles and her foundation, you appeared in person in support of this charade. This issue came to light when in January 11, 2023, 3 medical professionals reported medical inconsistencies in your story to the Eldridge Police Department. The Eldridge Police Department worked extensively with those medical professionals to discover inconsistencies with your story of you having cancer and leukemia. They investigated your social media posts, your interviews, your news stories, and other sources. Many medical inconsistencies were discovered. It was discovered that you had adopted or essentially parroted and used as your own other cancer patients' stories. Search warrants were applied for and granted, and your home was searched, and it was discovered that you had things to support your fake cancer claims, such as a wig, IV bags filled with cotton balls, feeding pumps, wound dressings, and other medical equipment. It's just hard for me to fathom what was going through your mind while you were making yourself up and using a fake IV or using to photograph yourself or fake bandages. It's hard to imagine what was going through your mind. After your arrest, to your credit, you were interviewed and admitted to not having cancer, not having a tumor that wrapped around your spine, and admitted to taking staged photographs of yourself to spread your story, and admitted to using other actual cancer patients' stories as pictures of you. You also admitted to receiving private donations that you would deposit in your checking account separate from the GoFundMe account. it is absolutely clear to the court that you engaged in a lengthy course of deceit. Today, you indicate, my initial reaction, quite frankly, was this lengthy course of deceit was motivated by greed or perhaps social media fame. I am not quite confident, as I was walking in here, that that is the case. But it is abundantly the case that this was not an isolated or momentary lapse in judgment. You were bold enough to be interviewed by the North Scott Press regarding your cancer. You frequently appeared on social media concerning your supposed cancer. You went so far as to speak to the National Pancreas Cancer Foundation. I understand you spoke to students and donors at St. Ambrose University. You spoke to actual cancer groups. You made many appearances, public and on social media, to push your fraudulent scheme. At any step along that way, you could have stopped. You could have stopped. It did not stop until you were caught. In sentencing you, I also have some concern regarding your tendency to divert blame to your family and your mother. I can accept the fact that your relationship with your mother and perhaps even your siblings was strained. I was not there. I do not know. However, I do not regard that as sufficient reason for, even if you did somehow think in a misguided effort to bring the family together, you were going to report that you had cancer. Okay, perhaps I could accept that as having happened. But to not, over a course of a year, to continue that charade and to actively promote it, not just remaining silent, but actively promoting on social media and through personal appearances, promoting yourself as a person with cancer. That is not a momentary lapse in judgment. Your attorney called an expert, Dr. Peitz, I believe, Peitz. I entirely agree with her conclusion that it is appropriate, for the reasons I will get to in a moment, that you are a good candidate for probation. You are a good candidate not to reoffend. I accept that I doubt that you will ever commit a crime like this again. However, deterrence of others is a very important goal of the criminal justice system, and I will get to that in a moment. My discretion today is in sentencing you is rather limited. You entered a plea agreement with the state whereby both parties, the state and the defendant, your counsel, recommend to the court that a suspended sentence for theft in the first degree be imposed. The concurrence of the court is a condition to that plea agreement. In other words, we wouldn't be here for sentencing today if the parties had not reached a plea agreement. So my decision here today is quite limited. My decision is to either accept the plea agreement or reject the plea agreement. While there is a very strong case can be made that the extent of your scheme requires incarceration, I can certainly appreciate the thoughts of the two women that testified in a very heartfelt way here today. I can certainly appreciate and understand their thoughts that the time in jail is appropriate. However, You have no prior criminal record. You were and are very young. You have been cooperative with the prosecution, and you agreed that at least the victims that directly donated to your campaign will be made whole by the restitution. You have also suffered a very real and substantial punishment of the local, national, and even international coverage of your crime. The court has determined that no further purpose would be served by rejecting the plea agreement and requiring the parties to take this case to trial, simply so the sentencing judge could have the option of placing you in prison, that would be the result if I did not suspend the sentences here today. So my decision is really down to choosing between a suspended sentence and a deferred judgment. Certainly I am bearing in mind again that you are very young, that you have no prior criminal history. For those of you in the audience that might not know what a deferred judgment is, it allows the court to defer making a decision on the appropriate sentence for a period of probation, typically 2 or 3 years. The defendant is placed on probation for that period of time. If the defendant successfully completes probation and commits no other crimes and pays all the restitution ordered, at the end of 2 years, the charges against her would be dismissed without the entry of judgment. This would mean that Ms. Russo would not have a conviction for theft in the first degree on her criminal record. It would also mean that she retains various rights that she would lose with a felony conviction, such as the right to vote. But I am firmly convinced here today that it would not be remotely just to defer judgment in this case and allow you to proceed further in life without the consequence of this criminal conviction for theft on your record. You engaged in a continuing criminal scheme that lasted for a year that requires more serious punishment of that, and that will serve as a deterrent to both you and others similarly situated. Frankly, I think there is a good purpose served by having people with whom you will interact in the future know that at one time you engaged in this criminal scheme. Serious crimes must have serious consequences to deter both you and others from such crimes in the future. Granting a deferred judgment, in my mind, would send the wrong message to others out there that might be inclined to commit similar crimes. And I say that, I will add that I say that with all respect to Ms. Cunningham and the county attorney's office. She is a fine lawyer who is actually typically quite stern with her recommendations, and I know that her recommendation for a deferred judgment is not one that she made lightly. I, however, for the reasons expressed, have a different opinion. And I also, while much has been made about the fact that the restitution will be paid, yes, the people that directly contributed will receive restitution, a monetary restitution, which is, I believe, in the full amount. That is a wonderful thing. However, that does not compensate. The full restitution is not made because in my mind, the fact that this false claim was made and this lengthy false campaign took place causes other people around the country, not even in this community, to hesitate to donate to those seriously in need, thinking that it is all, it's likely a hoax or likely a fraud, or, oh, those people, it might be a scam. So this crime did not just affect those people who directly donated, but people out there who might be inclined to or hesitate to donate to other causes in the future. So for those reasons, I am not comfortable and will not grant a deferred judgment. Pursuant to the defendant's plea of guilty to the crime of theft in the first degree in violation of Iowa Code Section 714.11, 2, or 3, and 714 and 702.91, and pursuant to Section 902.3 and 902.9 of the Code, it is the judgment and sentence of the court that you be committed to the custody of the Iowa Department of Corrections for an indeterminate term of incarceration not to exceed 10 years, and you shall pay a fine of $1,370, which is not suspended. The Iowa Medical and Classification Center at Oakdale, Mitchellville, Iowa, is designated as the reception center to which the defendant shall be delivered by the sheriff. However, for good cause shown, the sentence just announced is suspended, and the defendant is placed on probation with the 7th Judicial District Department of Corrections for a period of 3 years. The terms of the probation will include that the defendant pay the restitution is in full, that the defendant commit no other crimes, and that the defendant perform 100 hours of community service towards the community service volunteer work that is to be selected by the probation department. I was inclined to specifically name a charity or an organization, but that might arguably impose some burden on that organization as well, so I will not specify which organization. The defendant is ordered to pay restitution in the amount of $39,385.79, payable as indicated in the order filed in this case on July 12, 2023. The law presumes that the defendant has the reasonable ability to repay Category B costs. Category B costs are costs from the clerk of court and court-appointed attorney's fees. This is the clerk's, are the court costs in this matter, Ms. Cunningham, this indicates the court costs are $58,486.62. I cannot imagine that that is accurate.
No, Your Honor, I would not think that that's accurate at all, and I don't even know why that figure would be popping up.
I wonder if they somehow somehow included the restitution, or I don't know, but it's a shocking amount, and so I am not going to, I am going to defer further hearing on the amount of Category B restitution pending for 30 days, pending clarification of this. There will, Ms. Yeager, I believe you are privately retained?
That's correct, Your Honor.
Okay, so there will be no restitution for court-appointed attorney's fees.
Correct.
Other than appeal rights and bond, have I left anything out?
No, Your Honor.
No, Your Honor.
Ms. Russo, now that you've been sentenced, it's my duty to advise you of your appellate rights. Under the Iowa law, because your conviction and sentence was as the result of a plea of guilty, there is no automatic right to appeal. Rather, if you wish to appeal, you must establish good cause for your appeal, and you must file a request for permission to appeal within 30 days. If you wish to appeal and you cannot afford an attorney or a transcript of these proceedings for that purpose, you have the right to make application with the court for court-appointed appellate counsel and a transcript of these proceedings, all at the expense of the state of Iowa, Just be aware that that must be done within 30 days. Also, be aware that at the conclusion of the appeal, you may be ordered to make restitution or pay back court-appointed appellate attorney's fees and costs as well. Bond on appeal is set at $13,000 cash only. I believe that concludes this matter, other than, as I indicate, I would like clarification of court costs before I enter any decision concerning that. Thank you. That concludes this case.
Thank you, Your Honor.